Good morning to those on the platform, bright and early this morning. Hope you're doing well.
Morning, Chair.
Good morning, Honorable Chair.
Chairperson, morning.
Good morning.
Did you manage to see the legal advice on the establishment of or what is the agreement on the establishment of Africa Export something Bank?
Yes, it was circulated to us. I will explain in the meeting, we had the preliminary report and we've only just received the final report from the legal advisors. So don't worry, this is just giving us some background so that when we meet on the 5th with DTIC, it will just make it easier for us. And we're also meeting with the ECIC. It's just to give us some background as to where we're going with this Afreximbank.
At least there's some because when I was reading it, I felt that I'm reading a legal document. I'm like, Haibo, were they not supposed to simplify it for us? No, I'll wait for the one that you have. Hey.
It was sent to us. It was
Madia? Yeah, no, I did read it. I think it was sent sometime. I can't remember when it was sent.
Yesterday it was also sent, the final one.
Yeah, there's one that the one from yesterday is the final one.
Yeah, boy.
Oh,
Yeah,
No,
it's a
we'll
bit
learn.
confusing, Honorable
Yeah,
Modise, but
we'll
I'm
learn
also
this
not,
English.
I'm also not a legal eagle.
Aye.
But I'm sure you're going to be much wiser after the legal advisor gives you some background as well.
No, it makes sense why law is the only profession where people go to the same school for 4 years, same exam, same assignment, everything, but they interpret it differently. I can't. Yeah, man.
I rest my case.
You know, doctors, if you go to a doctor and they agree that you need a transplant, they all agree that you must have a surgery. Law, this one says this one says this, but they did the same exam, same assignment. So let me wait for the expert to explain. I can't. No,
Okay,
wait.
Honorable.
Thanks,
All
Chair.
right. Thank you. Colleagues, good morning, and good morning to everybody else on the platform. As you have noticed, there
Recording
is
in progress.
nobody from the executive because we do not need the executive today. We're just sourcing a legal opinion on the Afreximbank issue that is at play currently. Mardia, before I carry on, could I ask you to please flight the agenda for us so that members are conversant with what will be discussed? Thank you very much for that. And with that, I'm switching off my video. Colleagues, the welcoming and apologies is the first on the table. I've done the welcome. Can I ask Mardia to table any apologies that were received? Thank you.
Good morning, Chair, and good morning, members. I have not received any apologies, Chair.
Thank you very much for that. Before we carry on with the subject on the table, could I just ask for a mover and a seconder on the agenda that is flighted before you? Honourable Pinar.
Thank you, Chairperson, and good morning, colleagues, staff. I move for adoption of the agenda.
Thank you very much. Could I have a seconder?
I second, Chair, Honorable Modise.
Thank you very much, Honourable Modise. I would just like to, before I hand over to the legal advisor on this issue, give the members a little bit of background with regard to this issue at hand. The week before last, or last week, I can't keep up, the management committee got together to consider the research report received by the legal advisor, and it was discussed. Honorable Dlamini was also part of this meeting, and in view of that, we then realized that the committee also has to have some background into this before we meet with the Department of Trade, Industry and Competition on the 5th of November. Now, as you will know, Mr. Hanif Abdullah provided us with research contents as well. And if you have compared the two, you will see that they differ vastly, the legal opinion and Mr. Hanif's research on this. Just keep in mind that his research was done on the initial preliminary report. So the legal opinion that we got yesterday is not the one that Mr. Hanif had. So please just keep that in mind. Now, what I want to bring to your attention is that the report found that the agreement is a multilateral treaty under Section 231 of the Constitution, and it also confirmed that accession would be legally sound and beneficial, provided that Parliament exercises its oversight role and implementation occurs through the Diplomatic Immunities and Privileges Act. Now, this issue has been on the table since 2015. And as Honorable Modise said just now on the platform, he's lost. Well, don't feel alone, Honorable Modise. I think you and I are on the same page. I'm also not a legal eagle, and that's why we're now getting the information from our CLSO with his opinion. That will then give us a basis to work from. Now, the CLSO's legal opinion, which was dated 8 October, takes a completely different view to that of Mr. Hanif, but I've explained to you why that is so. And then doing my own research and my own reading, we must also then take into consideration that this accession supports our trade relations across Africa, and it will improve access to trade finance for South African exporters and importers. And it's in view of that, it's not going to create any new fiscal commitments, since we already hold shareholdings through the ECIC. The Durka opinion remains clear that it is a treaty requiring Parliament's approval under Section 2312, and the immunity provisions are consistent with those in similar financial institutions. So everything basically has been looked at and into, and it would appear as if everybody is on the same page. I just wanted to give you clarity with regard to Mr. Hanif's approach and the legal opinion we've been given. But Mr. Hanif did not have the latest legal opinion. So his research would have been completely different. And in view of that, I would like us to approach this matter now with constitutional care and strategic oversight, so that we ensure South Africa's interests are firmly protected and advanced. The Portfolio Committee also sat yesterday, and according to information, it would appear as if they have approved the going forward on this matter. There are just other issues that they still want to brainstorm, but it had nothing to do with the legal opinion. And then in view of that, I'm going to allow the parliamentary legal advisor to brief us on his opinion. And after that, we can deliberate, and then we will discuss our Limpopo oversight and adopt the minutes of 9 September. Could I then please hand over to the representative from the CLSO office to take myself and the members through your opinion? Thank you very much.
Thank you, Honorable Chairperson. Good morning, Chairperson, and good morning to all members and officials that are present in the meeting. Perhaps if you can ask Madia to assist me with flighting the presentation so that I can just go through each slide by slide with the members. Madia, can you assist?
Oh, my apologies. I thought I was already doing that. Let me just okay, can everybody see my screen?
Yeah, yes. Okay, thank you, Madia. Perhaps before I start with the presentation, just to clarify that I heard there was a confusion with regard to whether we issued two different opinions, one being the preliminary and the final. It's the same opinion that we sent out on Monday, but the one that was circulated yesterday is just the presentation in a presentation form. Otherwise, in terms of the content, it's exactly the same. So we did not change anything from the one that was sent out to the committee secretary on Monday. I just wanted to clarify that. And I will try to explain it to the best of my ability so that we understand the contents of the opinion. We try as much as we can to move away from using the legal jargon so that it can be understood in the most clearest form by the members. Okay. The Constitutional and Legal Services Office was requested by the chairperson of the Select Committee on Economic Development and Trade, that is the chairperson, Mrs. H.S. Boshoff, to scrutinize the agreement for the establishment of the Africa Export-Import Bank and advise the Select Committee if it is an international agreement in terms of Section 231 of the Constitution of the Republic of South Africa. It is understood that the committee received different legal opinions from the Office of the State Law Advisor and the Department of International Relations and Cooperation in respect of the same agreement. Now, the legal question then to consider is whether this opinion is whether the agreement is an international agreement in terms of Section 231 of the Constitution. This is section that deals with the ratification of agreement, is Section 231, the negotiations and the conclusion of international agreements. In terms of the Constitution, the negotiating and signing of all international agreements is in the exclusive purview of the national executive. In relation to international agreements, Section 231 of the Constitution provides that the negotiating and signing of all international agreements is the responsibility of the national executive. An international agreement binds the Republic only after it has been approved by the resolution in both the National Assembly and the National Council of Provinces, unless it is an agreement referred to in subsection 3. An international agreement of a technical, administrative, or executive nature, or an agreement which does not require ratification or accession entered into by the National Executive binds the Republic without approval by the National Assembly and the National Council of Provinces but must be tabled in the Assembly and the Council within a reasonable time. Subsection 4 states that any international agreement becomes law in the Republic when it is enacted into law by national legislation, but self-executing provision of an agreement that has been approved by Parliament is law in the Republic unless it is inconsistent with the Constitution or an Act of Parliament. In common parlance, within the context of international law, any reference to an international agreement is construed to be synonymous with a treaty. A treaty is defined in Article 2, subsection 1A of the Vienna Convention on the Treaties of 1969, and is defined as an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments of whatever its particular designation. In the matter of Huxon versus President, the term international agreement, as it appears in Section 231, came under judicial scrutiny. It was argued that the term is used in Section 231 in the narrow sense of the word to refer only to legally binding documents. Informal or legally non-binding international agreements fall outside the ambit of Section 231. The Constitutional Court in Huxon, which is another case, stated that although the judicial determination of the existence of an international agreement may require the consideration of a number of complex issues, the decisive factor is said to be whether the instrument is intended to create international legal rights and obligations between the parties. That was the Constitutional Court decision in the year 2000 in the same matter of Huxon. The pertinent issue to consider is whether the agreement in question complies with all definitional elements of an international agreement as defined in the Vienna Convention and thus within the realm of Section 231 of the Constitution. In order to address the question of whether the agreement is an international agreement as contemplated in Section 231, our starting point is the definition of treaty as defined in the Vienna Convention. The Vienna Convention on the Law of Treaties is an international agreement that regulates the negotiation, conclusion, and termination of treaties between sovereign states. The Vienna Convention is recognized as part of customary international law, as confirmed by the Constitutional Court. The Vienna Convention stated that a treaty is an international agreement between states that is governed by international law. Now, let's consider the signatories to this agreement in our analysis. In terms of Article 4 of the agreement, that is the Africa Export-Import Bank Agreement, the membership is open to all independent African states. The agreement, even though it is multilateral in nature, its signatories are not exclusively limited to states or between states and international organizations as envisaged in the provisions of the Vienna Convention. Membership extends to public and private banks, financial institutions, and African and public and private investors, as well as international financial institutions, economic organizations. Further, non-African states, bank, financial institutions, and public and private investors may also become members. Membership is acquired in accordance with the provisions of the agreement upon subscribing shares of the capital stock of the bank. On proper constructions of the provisions of the Vienna Conventions, treaties can only be concluded between states or between states and international organizations and between international organizations. In the matter of Law Society of South Africa and others versus the President of the Republic and others, in a minority judgment, Justice Cameron stated that only a sovereign state or an international organization can fall foul of international law of treaties. Only these creatures of international law have the capacity to become party to a treaty and as corollary to breach the provision of a treaty. I think the significance of this judgment was to state clearly that parties to an international agreement is only the subject of international law, which is sovereign states or international organizations. Having regard to the above, it is evident that private financial institutions, for example, are not creatures of international law and thus lack the capacity to be a contracting party to a treaty in terms of the Vienna Convention. It is only sovereign states and international organizations that can be parties to international agreements or treaties. Moreover, it is tried that international agreements are governed by international law, as parties to such international agreements or treaties are generally subjects of international law. However, it is noted that Article 3 of the agreement stipulates that the Afreximbank shall be an international institution with full juridical personality governed by domestic laws of the participating or contracting states. Furthermore, Clause 1 of Article 7 of the agreement provides that legal proceedings may be brought against the bank in any competent court where the bank has a representation or agent agrees to be sued. Further, Clause 2 of Article 7 states that dispute arising in connection with the operation of the bank shall be subjected to conventional business practices and ordinary legal processes applicable thereto. Next slide, please. Our view is that the agreement does not comply with the requirements of any international agreement as contemplated in Article 21A of the Vienna Convention, and thus does not fall within the ambit of Section 231 of the Constitution. Also, the agreement makes a provision for exemption from taxation, which I also want to also delve into that. Article 14 of the agreement provides for the exemption of Afreximbank, including its income from all forms of taxes and customs and duties. In terms of South African tax laws, it is tried that the worldwide income of a South African tax resident is subject to normal taxation, while non-tax residents are only subject to tax in South Africa to the extent that they have income from a source in South Africa. However, Article 14 of the agreement does not distinguish between an income derived from a South African source and worldwide income, and has a blanket approach to tax exemption. Our view is that Article 14 of the agreement may conflict with South African domestic tax laws to the extent that this clause provides for tax exemption. Moreover, South Africa has concluded double taxation agreements with various states, and it is unclear what impact, if any, this provision of the agreement will have on such DTAs. Accordingly, we advise that further consultation with all the relevant stakeholders, including the National Treasury and South African Revenue Service, is required to ensure alignment with the South African taxation laws and policies. Next slide, please. Furthermore, we noted the agreement provides for restrictions on litigations against the bank. In particular, Article 7 of the agreement precludes any participating state or signatory to the agreement or shareholder and natural or juristic person from instituting legal proceedings against the Afreximbank in respect of transactions governed by arbitration agreements, matters pending before an arbitration tribunal, and personnel matters. This provision in the agreement may constitute an infringement of the right of access to courts as enshrined in Section 34 of the Constitution, which provides that everyone has a right to have any dispute that can be resolved by the application of law decided in a fair public hearing before a court, or where appropriate, another independent and impartial tribunal or forum. That is what Section 34 of the Constitution provides. In Social Justice Coalition and others versus the Minister of Police and others, the Constitutional Court held that the right of access to courts is inimical to the notion that for rights to have a real meaning, they must be capable of being enforced, and that enforcement of rights through the courts are an important feature of the broad machinery of democracy and the concomitant commitment to protect human rights. Furthermore, the provision impedes any natural or juristic person from taking legal action against Afreximbank in respect of personnel or labor matters. This provision, in addition to its conflict with Section 34 of the Constitution, may also infringe on the employee rights entrenched under Section 23 of the Constitution and the Labor Relations Act of 1995. Next slide. In conclusion, in view of the above facts, we are of the view that the agreement does not comply with the requirement of an international agreement or treaty as contemplated in Article 21A of the Vienna Convention and Section 231 of the Constitution. Our view is premised on the fact that the agreement is not concluded with subjects of international law, that is the sovereign states and international organizations, but is also open to public and private banks and financial institutions. That is our view as the CLSO office. Thank you. Thank you, Honorable Chairperson.
Thank you very much for the briefing background. Before we switch over to questions and answers, I would like our Secretary, Mardia, just to come in for a second or two. Thank you, Mardia.
Thank you, Chairperson. Chair, I just wanted to raise that one of the reasons why the Office of the Parliamentary Legal Advisor was engaged is because the DIRCO opinion, like Chairperson correctly mentioned, the DIRCO opinion did mention, did have a certain view, but the Office of the State Law Advisor's view was pretty much consistent with the view that was just presented by the Parliamentary Legal Advisor. I'm sure you will also come in more as he responds to questions from members, but also just to say that beyond this meeting, the committee is supposed to engage on this agreement with the DTIC on the 5th of November. And actually, towards finding consensus on this issue, the legal advisors of the DTIC, DIRCO, and Parliamentary Legal Services have also undertaken to engage just towards finding consensus on and trying to understand where the differing legal opinions lie. So I just wanted to make that input, Chair.
Yes, thank you very much for that. That is what I was going to mention. I think there's a bit of discrepancy between what I said and how it was interpreted. I'm not trying to say that the two legal opinions differ. the preliminary one and this one. I'm talking about the initial one because this has been on the table since 2015, because the earlier opinion treated the Afreximbank agreement as an international agreement within the meaning of Section 231(2) of the Constitution, which ultimately requires parliamentary approval before binding South Africa. But reading through the opinion on 8 October, Mr. Samani, it takes, in my view, an opposite stance. It asserts that the agreement does not qualify as an international agreement under Section 231 because its membership extends beyond sovereign states and international organizations to include inter alia private and public financial institutions which fall outside the Vienna Convention's definition of treaty. And this is where I am absolutely at loss for words, because I cannot put my mind around it because I'm not a legal eagle, as I said. So having said that, I'm going to leave it with you, and I'm going to afford the members the opportunity to table any questions or clarity-seeking questions with regard to this. So if I can ask for hands to be put up so that I can identify who would like to ask questions on this presentation by Mr. Samani. Honorable Pinar, I see your hand. Just hold on. Honorable Modise. All right, let's take those first two, and then we'll come back for a second bite. Honorable Pinar, thank you.
Thank you, Chairperson. Chairperson, honestly, I don't have any questions. I think it's very, very clear. The conclusions of the staff and the interpretation thereof. So no, there's no major question from my side. It's just a matter of yeah, like you said, there's some discrepancies about the international side, but I'm sure you already covered that, and maybe you can further elaborate on that explanation thereof. Thank you, Chair.
Thank you, Honorable Pinar. Honorable Modise.
Good morning, Chair. Good morning to honorable members and colleagues on the platform. A quick one, Chair, because I mean, at least I've got this Afrikaner with now. I'm Dear Makar. I just want to check, how do we then move forward treating this this bank? Do we treat it as because it's not my goodness, the report says it does not fit into being recognized as one of those international bodies of some sort. I don't know whether does it fit to be recognized as a continental issue like your Africa free trading, what, or does it fit to be recognized as a regional issue like your SADC or a SADC and ECOWAS? And I'm not sure how do we then treat it moving forward. I just need to be clarified. I'm extremely confused, Chair.
Don't feel alone. I do not know who Motusi's iPhone is, so if you could identify yourself, then you are welcome to ask questions.
Thank you very much.
Oh, our
Yes.
new member. Sorry, thank you very much. Luckily, you were greeted with warmth in Honorable Modisi's committee meeting yesterday. So welcome to this as well. Please go ahead.
Yes, thank you very much. A very good morning to everyone in the meeting. And thanks again for being part of this meeting as a new member. I just have got two things to raise. One is that the legal advice that we just got now relied mainly, I may be wrong, but I stand to be corrected, relied mainly on the Vienna Convention to a point where he then said that This bank does not actually conform to the agreement is actually not in order. Now, I want to ask that this agreement was done in 2015, and the legal advisor did indicate that if the agreement is done within a reasonable time, it must be subjected to Parliament for approval so that it becomes an agreement that is acceptable in the country. So I want to check, when the agreement was done, did that process happen in terms of the matter being subjected to Parliament for approval? That is just the first one. Number two is that what really brought this matter on the table that we as a committee assist, and beg your pardon, I'm only new in this committee. Maybe these may have been the discussions that the committee had before, but what really brought the matter to the surface to an extent that a legal opinion had to be sought on that matter. That is just number two on my side. And then number three is that why I'm a bit worried. Before I go to being a bit worried, the legal opinion from DERCO says something different, if I heard you correctly, from this current legal opinion where DERCO recognizes that. And we know the role that DERCO has to play to as far as bringing investment into the country through in partnership with the DTIC. Now, I want to find out what is the view of the DTIC on this matter, since we know what is the view of DERCO, which DERCO agrees that the agreement is fine. What is the view of DTIC on this matter? And the other thing that I said I'm a bit worried is that why are we selectively dealing with the issue of the Vienna Convention? And I'm saying this because I served when I was in the National Parliament in the Portfolio Committee on International Relations. There's an issue of the Taiwan and being, in Pretoria, of which in terms of the Vienna Convention, Pretoria remains an exclusive area where countries where South Africa has a trade agreement with, they must be housed in Pretoria. And Taiwan, in terms of the Vienna Convention, is not supposed to be in Pretoria, but must rather find space. Can either take it to Rustenburg or Taung in the northwest, somewhere like that. So I'm a bit worried that it looks like since the GNU, there's a concerted effort to now try and selectively deal with issues that were concluded in the previous administration. Now they are coming to the fore because issues must then go to Parliament, and then we then have to reverse. Why it looks like everything about Africa is a problem. Why are we not speaking also on the issue of Taiwan, to say Taiwan must move its offices from Pretoria, because Pretoria remains an exclusive reserve for countries that have got that trade relation with South Africa in terms of the Vienna Convention. So my worry is around the Vienna Convention because DTIC is involved there. DERCO is involved there in the issue, but we are not speaking on the same voice in terms of dealing with implementation of the Vienna Convention in totality. Thank you very much, Chair, for the opportunity.
Thank you very much for your maiden speech in my committee, Ms. Honourable Montwedi. I just think that those questions that you have posed right now should be kept in abeyance and pose them when we have the meeting with DTIC on the 5th of November. I hear where you're coming from, and the fact that you are seeking questions with regard to Taiwan's office and this one's office and the Vienna Treaty and so forth. So the questions that are applicable to our legal advisor, Mr. Samani, I would like to hand over to him to be able to respond to that, and we'll take it from there. Over to you, Mr. Samani.
Thank you, Honorable Chairperson. I've noted the comments by Honorable Pinar. Unfortunately, he did not pose any question for me to respond to. Now to the question of Honorable Modise, who actually asked how do we move forward in relation to this matter. Perhaps before I respond to his question, I will deal with some of the questions that were asked that specifically may be related to my opinion from Honorable Mutwendi. I noted some of the questions will be kept in abeyance for the meeting on the 5th of November. But there is one particular question which I think I need to actually respond to, that he says that the legal advice relied mainly on the Vienna Convention. On the definition, or rather on what constitutes an international agreement, the Vienna Convention is a source, is an authority in terms of international agreements. That is the reality. But over and above that, I think I may have cited one or two cases that speaks exactly to the Vienna Convention being a part of our international customary law. So it's not necessarily to the exclusion of the African states, but the definition states that this is a treaty is defined as an agreement between sovereign states, including agreements among the African states. They also fall within that realm of an international agreement as contemplated in the Vienna Convention. And then now going back to the question of Honorable Modise, how do we move forward in this matter? I think it's common that even legal advisors or they will have different views on a very same issue. I think that is quite normal. Hence, we have in our jurisprudence the hierarchy of our courts, because if a person is aggrieved by the decision taken by a lower court, you will take it to the next level with the hope that that particular court will come to a different conclusion. That is something that is pretty normal. Now, in this instance, my advice would be, if we are confronted with a situation like this where there are two divergent legal opinions, the best way would be for the department to obtain the view of a senior counsel that can maybe opine on this particular issue, just to get some kind of clarity on that, if where we are confronted with the situation of divergent legal opinions. Thank you very much.
Thank you very much, Mr. Samani. Sorry about that. Colleagues, it is a very difficult opinion to understand. We are not wired for these legal issues, but I think Mr. Samani has given us a broad overview of issues that could be at play and how we, when we meet with the DTIC on the 5th of November, can engage them, especially in light of what Honorable Montwedi said. So having said that, I would just like to know, I see his hand is up again. Honorable Motweni, is that a legacy hand or is that a new hand?
Oh, my apologies. I didn't lower my hand. It's a legacy hand. Thank you.
Okay, thank you very much. Colleagues, in light of what we've heard now from Mr. Samani, I would just like to get your view on whether you are reasonably at ease to be able to engage DTIC on the 5th of November. I think more clarity will be given with regard to some of the questions as raised by Honourable Montwedi, and we can take it further on that day. So we have now heard what the legal opinion is. We also know that the Portfolio Committee on DTIC sat yesterday discussing everything with DTIC after having the legal opinion presented to them as well. And they were all in unison that they can carry on with the accession to this agreement. So I think we should keep everything in abeyance right now, and then on the 5th of November, we can brainstorm it further with DTIC. So in light of that, Mr. Samani, I would like to thank you again for presenting to us and giving us a background to this agreement. I am still very much confused, as Honourable Modise also said, but I think clarity will prevail at the meeting on the 5th. So in light of that, and no more questions, as I do not see any other hands, you may be excused, but you are more than welcome to sit in whilst we're busy with the internal administrative work this committee still has to do. Thank you very much.
Thank you, Chairperson. I'll like to be excused as I have another committee meeting in the next few hours or so. Thank you very much.
Okay. Thank you very much.
Thank you. Thank you. Bye-bye.
Colleagues, Mardia, the next item is the oversight report that we conducted in Limpopo. We have had this report in front of us for a considerable time. I take it everybody has read it. And in view of that, I would just like to know if there are any corrections. If not, could I ask for a mover and a seconder? Honourable Pinar.
Thank you, Chairperson. I move the adoption of the report.
Thank you very much. Could I have a seconder? I see Honourable Modise and Honourable Dlamini's hands are up. Honourable Modise.
Thank you, Chair. I had made a commitment that I wanted to submit my take on the report. Unfortunately, Chair, I'm sure you're also aware I'm busy with my PhD research proposal, so it's taking too much of my time. So I did not have the chance to put down my views on the report. What I've picked up is that the report, Chair, does not acknowledge the commitment that we made as the committee in our first meeting when we arrived in Limpopo, Polokwane, where we met with the MEC. I think the MEC was in that meeting, where we made a commitment that we're going to give the new board a chance to showcase the capacity and the capability that they've projected in our meeting with them. It's one thing that I would want us to flag, that we acknowledge that there's a new board and we are prepared to give them a chance. We might not have agreed as to how long do we want them to be, so that before we can come back and check the work that they have done. But we agreed that we are going to give them a chance. We acknowledge that they are a new board. Second to that, the issue, I don't know which one is Makado and which one is Musina. But where we slept a night before, after we left Polokwane, the first stop we made before we went to the municipal building, I'm not sure whether it's Musina or Makado, where we were told that there are tar roads, there's a fence that has been erected and all of that. And we got there was nothing, absolutely nothing. Similar to the second spot where we stopped and all we could see were trees and all of that. The report does not come out strong in terms of our disappointment in relation to the report that was presented to us a day we arrived and what we saw on the ground. And I would love if the report can emphasize that the committee was extremely disappointed and that we feel that the MEC of economic development, if that's how they refer to him in Limpopo, must take a serious action against those officials that were in the meeting and presenting to us the report about the amount of work that they've done and the money spent, because the money spent does not correlate with the amount of work on the ground. For me, Chair, if we could just extrapolate those and highlight them sharply, I have no problem in moving and supporting the report. Thanks, Chair.
Okay, thank you very much for that. If I cannot recall the board issues, I know what you're speaking of, but I'm sure I read it in the report. Mardia, can you just enlighten me on that, please?
I think that was highlighted in the body of the report, Chair. But for example, if you look at the I think it is under section 6, committee observations and findings. I think I'm just going through it now. Yeah, point 8. I think it's on. I don't know if I'm still sharing the screen.
No, you're not.
Okay, let me go. Point 8 on page 18. Point 8, here we go under observations. It says here, as already highlighted in this report. So obviously this issue was highlighted previously in the report. The provincial government has spent more than 200 million. Nothing demonstrate that funds allocated have been used effectively and efficiently and effectively. Historical allegations of wasteful expenditure have not been fully addressed. The zone still looks like a deserted development project. There is no value addition. This is direct assault to the financial governance and legislative obligations. The new SEZ board has acknowledged these governance failures and has undertaken to conduct a forensic audit. However, the absence of publicly accessible audited financial statements since 2017 has eroded stakeholder trust. Point 9. The new board has undertaken to review historical contacts and initiate consequence management, but the committee noted that this process has been formalized through a forensic audit to identify and prosecute any irregularities. The committee says that the restoring of financial discipline is critical to re-establishing the credibility of the SEZ. So this was further amplified in the observations, but I think the point of Honorable Mudisi was also captured in the body of the report. But I think in terms of the earlier comment about the board and giving the new board space, we can maybe add it under the recommendations as well, if it hasn't already been correctly captured there, Chair.
Okay, thank you. We can reword it to allow Honorable Modise to feel more at ease. But I know we did have it in the report. Honorable Dlamini?
Thanks, Honorable Chair. Good morning, and good morning to the colleagues on the platform. Chair, my issue was I could not recall which paragraph was, but there is where the report says that we agreed that there has to be a prioritization of the private sector in terms of dealing with the issues of those. I don't recall us agreeing that the private sector must be prioritized. Prioritized in doing what?
I hear what you say. Yes?
Yes, so that is my issue, that we need to erase that, delete that particular sentence, because that is not what we agreed upon. What we agreed upon is that we need to give the government of Limpopo the relevant MEC to ensure, and the municipalities, including the board, to ensure that those SZZ are revived, and everything that has to be implemented in making sure that those projects are moving forward do take place. That is what I can recall, Chair. Thanks.
Thank you very much for that observation. Mardia, if you could just make note of that. Honourable Farmer.
Thank you, Chairperson. I hope I'm audible.
Yes, you are.
Thank you, Chairperson. If 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 the proposal of Honorable Pinar gets a seconder, I would move for counter proposal not to adopt this report until such time that the committee can have a physical meeting on it and discuss it, because there's a number of issues in this report that I don't think we've agreed upon, and the report is making some statements that I'm not sure we did agree to. So Chairperson, I would like to, if it does get a seconder, to make a counter proposal. Thank you.
Honourable Farmer, this is why the report is sent out, so that it can be read and your observations or corrections be submitted to the Secretariat. They only have a certain time to draw up reports on oversight and present it to the powers that be. So it puts us in a very difficult situation. So can we do that now? Could you please raise your concerns so that we can have a look at it and incorporate it into the report? Honourable Farmer?
Chairperson, I have made
Yes.
my point clear. I will.
Okay, colleagues, we've got a proposal on the table that this report be workshopped, but before I do that, Mardia, can you just enlighten us as to timelines from your side before I hand over to Laduma?
Chair, there is space for the committee to consider this report. Obviously, I think ideally speaking, we should finish by the end of this year. We should have cleared all the outstanding business before the committee, including outstanding oversight reports. So if we can conclude this before Parliament rises for the end of the by the end of the fourth term, I think we should still be fine. But I see Laduma, as you indicated, Laduma also raised his hand. I think he also wants to come in, Chair.
Yes, I saw his hand. Thank you very much. Laduma?
Thank you, Chair. Can you hear me?
We can hear you loud and clear.
Yes, thank you, Chair. Let me just pack what I was going to say. I was trying to see how we can accommodate the issue of saying that the report is sort of highlighting or prioritizing the private sector participation. But I think we tried to tone it down or lower it in the sense that is to accommodate private sector participation in the development of the special economic zones. And if members will remember well that there was the review done by DTIC and also highlighting as sort of a best case model. I think is it the Tshwane Special Economic Zone that has sort of a private sector participation component. And we also highlighting that maybe it's another option that could be looked at in terms of developing a special economic zone that will assist the Musina Makado especially land economic zone. It was not an issue of, maybe we worded it very wrong. It was not an issue to say prioritize the private sector, but was more to say, how do we accommodate private sector participation, but not only in terms of looking at how the fiscus is constrained, but in terms of leveraging private sector capital in supporting the development of the special land and economic zone. So we're highlighting that and trying to look at the review, the DTIC review, but at the very same time, new developments in terms of developing special economic zone, and particularly when government is challenged with the fiscal land issues. That was the issue that we're trying to learn to highlight when we raise the private sector. But maybe something that we just need to see how we can rework that paragraph, so that it's not seen that we are sort of championing, if we put it that way, private sector participation, but to accommodate it, take into consideration the issues that I've also raised.
Thank you very much for that. Indeed, I think it is the wording that Honourable Dlamini is referring to. So we will be giving an opportunity again for everybody to study this document. This is the last opportunity, but to be able to get together to workshop this report, we will have to look for a date, and this could be after ours because our committee commitments have already been scheduled and approved by the powers that be. So please be aware that it will have to take place after hours. So Mardia, in light of what has now transpired, will you please just ask members to provide a date so that we can reach a consensus on a unified date to discuss this report. But in the meantime, please, to save time, make note of the discrepancies, as you say, Honourable Farmer, exist and you're not happy with, so that when we do speak to the report again, everything is available and the Secretariat can incorporate it. And if I could ask that to save even more time, your observations or your concerns be sent to the Secretariat and they can start capturing it into the new report. In view of that, could I just have a mover and a seconder for the proposal made by Honourable Farmer that we re-look this report? Honourable Dlamini?
Thanks, Honourable Chair. I do support the proposal and your summary as well. Thanks.
Thank you. A seconder? Nick, Honourable Pinar?
Thank you, Chair. Yes, it's fine, Chair. If that's what smooth this report over, I've got no issue to accommodate Honourable Farmer. So I second the recommendations. Thank you.
Thank you very much for that. So Mardia, you have some extra work on your table, especially now in light of 2 vacancies within this committee. Colleagues, the next point on the agenda is the minutes of the 9th of September. It was circulated. If I could ask Mardia just to flight the minutes so that you can become conversant on the minutes that we will be discussing or going through. Thank you.
My apologies, Chair. I was not in the meeting. Can I be excused?
Yes, you're more than welcome.
This is the last item. Thank you, Chair.
Thank you very much. Colleagues, this was the briefing by the AG on the Unemployment Insurance Fund that took place on the 9th of September. Could I just ask that you all check whether you've been captured as present or apologies have been noted if you were not there? Okay, please just go down, my dear. Thank you. Opening and welcome. Next page. Next page. Thank you very much for that. Could I have a mover and a seconder? And then if there are any matters arising from the minutes or corrections, that also be noted. Thank you. Honorable Modise, Honorable Mukwena.
Is this the meeting where we had two meetings in a row? The first one was with the Office of the AG, the second one was with the Department of Labor and Employment.
That's
It
right.
was a virtual meeting.
That's right.
Oh, no, I move for the adoption. It's just that I've changed phones, so I don't have my document with me, but I move for the adoption because I had read those minutes. Thanks.
Thank you, Honorable Modise. Honorable Mukwena.
Thank you, Chair. Good morning to everyone. I would like to second
Thank you.
Modise.
Thank you very much for that. I see you have a barrel surname, Mukwena Zondi. Is that
Yes,
the name?
yes, officially I'm now Honorable Mokoena Zondi.
Oh, okay.
Yes.
Well, what happened in the meantime? Well done. I don't know what transpired, but we will note that.
No, I got married last year, December. I just haven't gotten around changing surnames until now.
Oh, okay.
Yes,
All right.
yes.
Now I've just seen it now. Congratulations on your marriage. I hope it is going to be as good as mine. For 46 years, I was married. Colleagues, thank you very much for availing yourselves for this meeting. And if I may just request that this legal opinion, that we try and become more conversant before we engage with the DTIC on the 5th of November. Maybe speak to your counterparts in the PC meeting to find out what their views was and why they moved for the adoption of the requests and the ascension that was given. And maybe there are some issues that they are still not happy with, then we are more prepared for our meeting on the 5th of November. In light of that, I would like to adjourn the meeting. Enjoy your...
Sorry, can I just raise one or two issues, Chair, if you don't mind?
Yes, you may.
Chair, just to say two things. As I indicated earlier, with regards to the legal opinion, the undertaking was that between the legal advisors of the DTIC Parliament and DIRCO, they would come together, hopefully before the meeting of the 5th of November. And I think towards finding some kind of consensus or common understanding with regards to this particular agreement. So hopefully by then we will be able to provide feedback to the committee on that issue. The other thing is just in terms of the upcoming oversight visit, thanks to the members who have provided the information, but there was a request for members to please complete the profiles. I think I did indicate in the meeting chat that we are dealing with a new travel management system and a new service provider that actually requires all that information before any kind of bookings can be made. So for those members who haven't yet submitted, if I could just ask if they can just please urgently send me the information so that we can include it and then submit that information to the travel agent. Just quickly, I have indicated in the meeting chat as well, but in terms of the oversight, we are expected to depart on Sunday the 19th of October and then go to Gqeberha, Port Elizabeth that day. And then, yeah, so it's going to be split between Eastern Cape and Western Cape. But at the next meeting, we'll be able to provide a lot more detail with regards to the upcoming oversight visit.
Thank you very much for that, Mardia. Colleagues, please can I ask that we attend to this as a matter of urgency. Mardia is under a lot of pressure. We know that Amanda left our committee to join the joint standing committee, and it makes it very difficult for her because she now has to do the secretariat work plus the logistical work as well. She's getting a bit of assistance from the PC secretariat or logistic person on DTIC, I think she said, but she's getting rep from leadership because the applications go in late because she doesn't have all the information required as indicated. So please, those that have not submitted their or completed their profile, that they do so ASAP and get it to her by close of business today. Okay, I see Honorable Nodada will provide hers today as well. So let's all follow suit and do that. Now, I've already adjourned the meeting, so enjoy your free afternoon as there is no plenary this afternoon, and we'll see you tomorrow in the House. Thank you very much. Goodbye.
Recording stopped.
Thank you,
Bye.
Chair. Bye.
Bye.